All right, let's get this started. So hello, everybody. Thank you for joining the Colorado HOA Information and Resource Center's HOA Forum. My name is Nick Altman, HOA Information Officer. With me here today is Amanda Lopez, Program Assistant, and David Donnelly, Education, Communication, and Policy Manager. Hi, Amanda. Hi, David.
Hi, good afternoon. Thank you all for joining.
Good afternoon, everyone.
Perfect. All right, just a quick disclaimer here. The information provided during this presentation is for educational purposes only and is not meant to provide, nor should it be construed as legal advice. Any legal question should be directed to a qualified attorney licensed to practice law in Colorado. Amanda is going to tell a little bit about what we do here at the HOA Information Center. Amanda?
Thank you. So what the HOA Information and Resource Center does, so we'll go over what the HOA office does. We provide information to homeowners regarding basic rights and responsibilities under the Colorado Common Interest Ownership Act, otherwise known as CCIOA. We also gather, analyze, and we report information through complaints and HOA registrations, create resource materials, provide education in forums such as this one, provide a website with the information for the public. We register HOAs pursuant to 38-33.3-401 in the Colorado Revised Statutes, and we provide an annual report to the legislator. What the HOA office does not do, so we are not a regulatory program. We do not mediate or we do not arbitrate. We cannot provide legal advice. The HOA office does not act as an advocate. We cannot assess fines or penalties. And the HOA office does not enforce an HOA's failure to register.
All right, thank you, Amanda.
You're welcome.
With that, I'm going to pass it over to David for a quick announcement on House Bill 1105. David?
Thanks, Nick. So everyone, many of you have reached out to the HOA Center over the last several weeks and expressed an interest in learning more about the HOA Homeowners Rights Task Force, which was established by a bill that we refer to as HB 23-1105. HB just stands for House Bill. So while today's presentation is you're here to discuss homeowners' rights and how to better assert your rights as a homeowner, this presentation is not specifically about HB 23-1105. So we're really not going to field a whole lot of questions about 1105 today. What I wanted to convey to you all today is that the division has created an important engagement tool that we developed with this task force specifically in mind. And so what I would really encourage each and every one of you to take an opportunity to share your experiences and to participate in that task force process. And this engagement tool can be found at www.engagedora.org. From there, that's actually a landing page. If you scroll down just a little bit, the first project that is available there is the HOA Homeowners Rights Task Force. And from there, you can take a survey, you can submit a story, or drop a pin on where your HOA is located within the state, and various other tools, as well as review what other individuals across the state have shared with the task force. So just a little bit of a plug there for engagedora.org for you. And again, if you have any specific questions about HB 23-1105, please do not hesitate to reach out to us. With that, back to Nick.
Thank you, David. Okay, so before we get into the presentation, just a couple of quick housekeeping items. For today's presentation, you'll be able to submit your questions in the Q&A feature on the bottom of your screen. In addition, the HOA Center solicited questions from the public, and many of you have submitted some quite thoughtful questions, and we appreciate that. We do have several panelists on board here who will help monitor some of the Q&A questions. While we can't guarantee that we'll answer all questions that were submitted, we will try our best. If your question goes unanswered, feel free to email us at Dora_Dre, D-R-E, _HOA inquiries at state.co.us. We'll see if we can pop that in the chat down there real quick. Great, so today's HOA forum is on homeowners' rights and legal proceedings in Colorado. As many of you know, the HOA Center exists to assist the general public in understanding their rights and responsibilities under the Colorado Common Interest Ownership Act, commonly abbreviated CCIOA. The center receives all sorts of inquiries ranging from how to properly conduct a meeting, questions related to regular and special assessments, and issues surrounding an association's ability to enforce their covenants. Board members contact us seeking information on how to craft their HOA policy, how to deal with an upset homeowner, some of the recent legislative changes that we've seen, and generally how to operate a homeowners association. Community managers might sometimes contact us wondering if their policies and procedures are in line with Colorado state statute. They may also contact us with questions pertaining to their registration status with the division. While we hear quite a bit from board members and managers, most of our inquiries do tend to be from homeowners who simply want to better understand their rights and responsibilities under state law. A large chunk of these types of inquiries relate to a homeowner's disputes between themselves and their association or board of directors. Sometimes a homeowner wants to know how best to proceed with a uncommunicative board or what association records they're entitled to. Other times they simply want to know more about how HOAs are operated. So while we cannot provide legal advice here, it's our ultimate aim to set consumers in the right direction by providing them with useful and informative resources related to their inquiries. With that, Colorado has many law firms that represent both the association and the homeowner with various types of disputes. While the HOA Center does not endorse any one particular party, such as a homeowner or association, we do firmly believe it's in the best interest of the public to understand all sides of the issue, whether that issue involves say a broken water pipe or outdated documents, or just simply how better to engage their community. So joining us today to help in this endeavor is the Colorado law firm Robinson and Henry, with guest speakers Peter Towski, Joe Novak, and Boyd Rolfson. Boyd Rolfson is a partner at Robinson and Henry. He specializes in real estate, civil litigation, and probate law. Boyd has represented clients on both sides of HOA-related litigation. Early in his career, he defended HOAs as an attorney at Hinman Sanchez. Since joining R&H, Boyd has represented homeowners in their disputes against HOAs. He's also served as counsel to banks and mortgage lenders in matters such as foreclosures, property disputes, and bankruptcy actions. Hello, Boyd. Nice to have you with us today.
Thank you, Nick. It's nice to be here with you.
And Joe Novak is a litigation and real estate partner at Robinson and Henry. He specializes in resolving disputes related to business, civil, and real estate matters. Joe often represents homeowners and community members against their HOA board. He is intimately familiar with the Colorado Common Interest Ownership Act and has extensive experience resolving disputes between HOAs and their members. Hello, Joe.
Hello, thank you for having me today.
Of course. And finally, we have Robinson and Henry, Senior Associate Peter Towski. Peter practices in civil litigation, real estate law, and business law. With years of experience as a former prosecutor, he brings a refreshing perspective to his clients' cases. Peter handles a variety of civil litigation matters, including contract disputes, HOA problems, and real estate issues, and also assists clients with intellectual property. Hi, Peter. Welcome.
Thank you, Nick. Good afternoon. Glad to be here.
Okay, and our guest speakers today will give a short presentation on their law firm and who they represent, as well as highlight some of the important aspects of the Colorado HOA legal landscape and how you, as an interested stakeholder, may learn more about your rights and responsibilities. After this presentation, the HOA Center will pose various questions to the panel related to Colorado consumers' rights, and the panel will follow those up with their expertise and knowledge of HOA law. We're very excited to have Robinson and Henry here today, and with that, I'll pass the baton over to R&H.
Great, thank you, Nick. I appreciate the opportunity to be here, to speak to you, and to be here with my colleagues. And we do a lot of work here at Robinson and Henry with homeowners associations. That's not the only work we do, but the three of us here on the call do have a good portion of that, so we appreciate this opportunity. So with that, we'll go ahead and go through the presentation. Next slide. Just to repeat the disclaimer of our own that was given in the beginning, I just wanted to add to it, really just repeating the same, that the information is intended just for informational purposes. It doesn't constitute any legal advice, and participating in this event does not form the attorney-client relationship. We've gone through kind of what the agenda is. We'll have a short presentation. Each of us will talk about just certain aspects of our perspective and what we practice, and some of the issues that frequently come up from homeowners as we represent them, and also some of the other parties that we represent. And then we'll get to some of the questions that have been asked, and see if we can go through some of the questions and provide some guidance there. First of all, who do we work with? We do have a large variety of different clients. Primarily, our clients are homeowners and condominium townhome owners, as opposed to the HOAs. We do have some opportunity to work with some of the HOAs and boards and represent them on certain matters, but the bulk of our work is representing some of the homeowners and with issues that they have with the HOA. I think that comes up, and I think homeowners often feel that they don't have a voice, and that it's difficult to have someone to work with. At the HOA, there's a law firm and attorneys that represent the HOA and the board, but the homeowners are sometimes left on their own. So we try and bridge that gap and help them with some of the issues. Sometimes it spills over into representing property managers or management companies as they are involved with those homeowners and with the HOAs. Next slide. First is kind of to talk about what, from our perspective, what the legal landscape is in Colorado. And this is something that I frequently talk about as I do consultations, is how are HOAs viewed from our perspective in Colorado, maybe as opposed to some surrounding states or other areas. I think Colorado laws, by and large, do favor homeowners associations. I think homeowners associations have a voice in Colorado and have the ability to operate in Colorado. And sometimes this is great news for Colorado communities and for homeowners, but sometimes, like everything, it provides some conflict and some difficulties with homeowners. I think as time has gone on, more and more legislation has gone through in the HOA world. I think that a lot of this legislation that has gone through has attempted to even the playing field, has attempted to assist and help homeowners when they do have disputes, to help them have a voice, to help them have the ability to, for lack of better terms, fight back against their homeowners association. So I think the legal landscape is changing constantly. It feels like we have new House bills that go through that are attempting to expand the rights of homeowners or contract the rights of the homeowners associations. Next slide. Well, we get a lot of calls from homeowners on a variety of issues and problems that they have, many that we can help with and that we can assist with them and provide help. However, whenever we get calls, I often have the conversation with the homeowner that with the homeowners association, it is a different animal than dealing with it than if you have, say, a business dispute or a dispute with just your neighbor. There are some other steps and remedies, and some of these are intended to be the path or the best remedy to go through in order to get due process. And so I have this conversation, and the way that I like to think of it is a homeowners association is often set up kind of like a small town government, if you will, where you have the board represents perhaps the town council who helps to make decisions, to promulgate rules for the homeowners association, to follow the laws, to follow the governing documents. And if there is an issue with the board, with board members, there are other remedies prior or maybe at the same time, other than simply seeking an attorney to file a legal action. And oftentimes these remedies can be very powerful, can be very effective, and are something that you can do at the same time as working with an attorney or before going to attorney. So some of the things that I recommend prior to consulting with your attorney on an issue, if you're homeowners, talk to your neighbors, talk to other members of the homeowners association, see if they're facing similar issues, similar concerns with the board, with the management company, with a fellow homeowner. You know, homeowners and homeowners associations are really designed to represent the best interest of the homeowners, and therefore, if there's a lot of homeowners that have that same voice and have those issues, that carries more weight with a board, with a homeowners association. So I always encourage them to talk to their neighbors, see if there's other neighbors that are having similar issues, and really combine forces. Secondly, to stay involved with your homeowners association. It's really easy to forget about it, to just pay those, you know, monthly dues and hope that they don't bother you. But there's an involvement that takes place. The homeowners association is designed to serve all of the homeowners and to help all of them. So attending board meetings, knowing what's going on, attending the annual meetings, taking your right to vote on issues that you have the right to vote with, to stay involved can help you understand what the actions of the board are doing and what the homeowners association is doing. And going a step beyond that is to take the time to become a board member. Most of these boards are volunteer positions, and they're not easy. There's a lot of different things that are taking their attention and that are that they're required to do. So if you have an issue, sometimes it's a good idea to put yourself in their shoes to become a board member. That really is some of the best way to make change and to improve a homeowners association or a board, is to participate yourself. And then finally, just to open up the lines of communication with your homeowners association, with the management company, with the board, work out a solution before trying to take legal action. Obviously, if you can work out a solution and come to resolution before that, that's the quickest and most efficient way to resolve those issues. Next slide. One of the reasons why I recommend that action prior to coming an attorney is because coming to an attorney to resolve your issue is because you always have to evaluate your risk versus your reward of taking legal action, because I think there are both. So if you go to the next slide, we'll kind of talk through a few of those. One of the biggest risks of hiring an attorney and engaging in litigation or legal action against your homeowners association is, what is that going to cost? Is it worth it? Is the cost that you're going to spend to do that worth the resolution of the matter that you're trying to work with? And there are many factors that go into that. Things such as how complicated is the issue? Are we talking about non-payment of dues? Is it an issue of enforcement of covenants, unfair enforcement of covenants? Is it some sort of damage that's happened to your property? How complicated is that issue? And also, how many parties are involved? Is it simply you and the homeowners association? Are there neighbors? Are insurance companies involved? All of these things can really complicate and drive up the cost of litigation and legal action. And then you have to ask yourself, is litigation even necessary? Is there another avenue or another source of resolution of my problem other than litigation or the legal avenue? Next slide. You know, and then finally, you have to understand the cost of you know, what happens if you do risk being unsuccessful in your legal action or lawsuit. You could find yourself owing, you know, attorney's fees on your own, as well as if you end up going to court and losing, you could also be on the hook for the HOA's legal fees as well. So you have to ask yourself, is that cost, are those bills, is that worth it for the issue that I'm dealing with? Perhaps you're only dealing with a covenant enforcement fine or dues of only a few $100s, and you could end up paying thousands or even tens of thousands in attorney's fees to try and resolve that issue. And as you can, you know, probably see, that's not really worth it from a business standpoint. Maybe it is. You know, different people have different motivations and reasons that they get to the point of needing and seeking legal help, and we understand that. We work with you, you know, whatever that reason is. But if it's simply a cost analysis, then those are things to consider, you know, before proceeding with legal action. Next slide. You know, and once you go through that process, then you have to decide whether you want to go ahead and hire an attorney, and what are those factors and considerations that you go through. And I'm going to turn my seat over to Joe Novak from our firm to talk about that a little bit.
Thanks, Boyd. Great job there. Appreciate everyone joining today. Appreciate the opportunity to speak with you all. As Boyd mentioned, I'm going to take over here and we're going to discuss a little bit about what to look for when hiring an attorney. CCIOA HOA disputes, they are a somewhat specialized area of law. And so you do want to be somewhat careful about, you know, the experience that an attorney has when discussing with that attorney, the types of problems you're dealing with an HOA. Let's go ahead and jump to that next slide. All right, so where do we look? First things you want to do, Colorado Bar Association. Colorado Bar Association has a list of attorneys that they recommend. They often have references to what areas of law those attorneys practice and things like that. So that's always a good thing, what you're looking for in terms of area of expertise. HOA, like I said, is a bit of a unique area, but you can trust someone who has real estate experience, negotiations. Those are the types of buzzwords that you're looking for when you're looking for an attorney. I encourage you to pull up the attorney's bio. Often, almost every attorney these days has a website and with a biography on their experience, their history. Take a look at it. See if you see things that indicate, I have worked with CCIOA, I have worked with HOA issues. And more importantly, have I represented board members or do I represent members of the community? As we touched on at the opening slides here, Robinson and Henry, our firm traditionally represents members of a community against an HOA. So we're a good fit for the people on this forum, but there are other law firms out there, I won't get into names, but they primarily represent the boards. And yes, we interact with those attorneys all the time. We are used to those attorneys. We have relationships with most of them, not all of them, for better or for worse. So you want to find out what type of clients these attorneys look for, what to avoid. I often say, when you're hiring an attorney, it's an interview process, okay? Attorneys cost thousands and thousands of dollars, and we'll touch on that in just a few minutes here, but you are investing a significant amount here, not only financially, but emotionally and time-wise. So if you have a conversation with an attorney and they're throwing things at you, oh, I can get this resolved real quickly, don't worry about it, this can go away, and they're not mentioning to you the costs of litigation, or as Boyd just touched on, the fact that if you sue your HOA and you lose, you're going to be ordered to pay the HOA their legal fees, which is in addition to your legal fees. So if you're interviewing an attorney and that attorney is not bringing these types of issues to light to notify you of the risks versus the rewards, as Boyd touched on earlier, that should be a bit of a red flag. You know, I often say a good attorney-client relationship boils down to good communication. And so if you're talking to an attorney and they're non-responsive and they don't respond to emails and they don't pick up your phone calls and you're sitting there going weeks without getting a hold of your attorney, that's not a good attorney-client relationship. And so you want to touch on these types of issues when you're interviewing attorneys, which leads me to the next point. Let's go ahead and jump to that next slide. What do you want to do when you are interviewing an attorney? Let's take a step back. You do want to interview an attorney before you hire them. Don't just Google attorneys and look at their biography and say, oh, they have an HOA background, that person's a good fit. You want to call them. You want to get a feel for the attorney. Again, you want to focus on experience, what type of communication, what type of clients do they represent. When you go into that first meeting with your attorney, it's really important that you come in educated for your own sake. You know, as Boyd mentioned earlier, it's important that you look at your declarations, have an idea of what those declarations say. CCIOA came into existence in 1992. If your HOA was in existence prior to 1992, they may not be subject to CCIOA. So find out, how long has my HOA been in existence? And then try to find out your board members. Make sure you have a list of names. Make sure you have your management company. A majority of boards hire a management company to assist them in running the HOA. Make sure you know who those management company names are, who the board member names are, what their roles are, the president, the secretary, the treasurer. Just that type of information helps us so that when we have questions for you about your HOA, you've already got those answers prepared and we don't have to do the, oh, you know what, let me get back to you on that. We'll circle back to that. It's easier for us to address questions when you come to those meetings prepared. Bring documents, as it states, gather your papers, bring your declarations, bring your bylaws, bring your rules and regulations. Those are the primary things that we want to look at as we start. Board meeting minutes. You are entitled to all of this information, and we'll go through some of that. I think Peter's going to touch on that, but there is a statute, and I can reference it, CRS 38-33.3-317. You can just Google that. You'll find that statute. It is a list of documentation that the HOA board is legally required to produce to any members of the community. So I encourage people often when I do consultations, I will say, you know what, before you hire us, why don't you make that formal request, get that information, and then when you're ready to hire us and get us involved, you've already hit the ground running. You've already got us the documentation we need. And then I believe creating a timeline is arguably the most important. You have to come up with a list of what happened, when it happened, why you believe it happened, and what did you do to try to resolve these disputes prior to getting attorneys involved. If anything, maybe you haven't done anything. But when you sit down and you create that timeline, it forces you to gather your thoughts and come up with a cohesive kind of plan to talk to your attorney about, this is what I'm upset about. If you don't do that, oftentimes people will come in and, you know, we all have our frustrations with HOAs. I mean, let's be honest, they're bullies, as I like to say. And so you come in and you know, if you're not organized, you're going to be scattershot. And I'm not happy about this, and I'm not happy about this, and I'm not happy about this. And us attorneys are going to say, slow down. What is our goal here? What is our end game plan? What are we seeking to accomplish? You know, if your goal is, I want to sue my HOA, then we're probably going to want to talk to you. Why do you want to sue your HOA? What is the outcome you're looking for? What are the risks versus the rewards? Let's go to that next slide. So here we go. 5 questions to ask an attorney. Experience. How many cases like mine have you handled? This circles back to, do you represent boards, management companies, or do you represent members of a community? And then ask about their experience. Have you sued an HOA board? Have you not, but engaged with an HOA board? Tell me about how you resolved some of your disputes without having to file a lawsuit. A good HOA lawyer should recognize that running to court and filing a lawsuit is your last resort. There's a lot of steps to take prior to running to court in terms of trying to resolve these disputes. So ask your attorney, tell me how you approach these disputes. Process. How do you, again, just circles right into my next question. How do you approach each of these matters individually? You know, tell me about the types, again, the types of people you've represented. What I mean there is, you know, our firm does 30-minute free consultations, and it's often, I'm very upset. And I saw this question, I think it's from Rob Klein. How can you organize your neighbors? I'm very upset. I don't like the way my board is handling this, but I don't want to spend tens of thousands of dollars of my own money to fight the board. And so how can you, attorney, help me approach this? How can we do that? And sometimes it's a matter of gathering your neighbors and coming up with a group that's going to fight the board together or something like that. Options. This is in line with process. Do you recommend we file a lawsuit? Do you recommend we open up the lines of communication, try to negotiate something? Many, though not all, HOAs have what's called an alternative dispute resolution process. And so before you can even sue your neighbor for a violation of covenants, or before you can sue your HOA, there's a requirement that you undergo a mediation. A mediation is basically an informal settlement conference. It's an opportunity for you, with or without an attorney, to address these issues and try to come to some kind of amicable resolution without the big fight, without having to go through court, without asking a judge or jury to find in your favor. Communication, I've already touched on this. How will I be apprised of my case? How often do we communicate? How often do you respond to my emails? Can I pick up the phone? Can I call you? Those are the types of things you want to know. Some attorneys may say, I respond to every email I get within 24 hours. Other attorneys may say, you know what, I will get back to you as soon as I'm able. Sometimes that may be weeks. So those are two different attorneys that you want to know. How is this person going to approach my case? How am I going to be able to communicate with that attorney? Likely outcome of the case. If you speak to an attorney and your first response is, don't worry, I'll sue these guys, we'll win and we'll get you all your money back, that's a red flag. HOAs, these disputes are complicated. CCIOA intentions are well-meaning, absolutely, but it is a poorly written law, and there are problems with CCIOA. And so, you know, if the approach is let's go sue, that should be a red flag. If your approach is let's reach out to the HOA, let's try to get their attorney involved, let's find out what's going on, let's take a look at their board meeting minutes, let's take a look at the way they're handling things, and then let's decide on our plan of attack. But you want to talk to your attorney and make sure they do have a plan. If their plan is let's just run to court and file a lawsuit, that's not a good plan. You want to try to resolve these things before filing a lawsuit, if possible. And if they do say, no, we need to run to court, make sure you understand why they're recommending that. Why are you not suggesting that we try a mediation? Why are you not suggesting we try to send a demand letter and negotiate this out? So those are the types of questions you want to ask your attorney. Go ahead with the next slide. The path to a solution. And so here is where I'm going to pass the buck over to Peter, and he's going to take over. Thank you all for your time.
All right. Thank you, Joe. Before you go too far, I saw a couple of people were asking for that records statute in CCIOA, if you still have it up. I think they'd like to write that down.
Yeah, I appreciate that. I'm going to go ahead and put that right into the question and answer. So if that doesn't show up, just let us know.
Awesome. Thank you, Joe. All right, good afternoon, everyone. My name is Peter Kowski. I handle a lot of HOA matters at Robinson & Henry, and I'm going to start with the path to a solution. So I think the general sense that you're probably getting at this point is that the lawsuit is the last resort. If you can avoid going to court with your attorney, that's the way to do it. So for general issues that are coming up with your HOA, I think what we all recommend is to get involved. You know, an HOA is meant to be a community organization. A lot of people have negative things to say about their HOA, but there's a positive side for it too. And getting involved and getting good people involved and being part of the community is really important. There's an opportunity for you to use the HOA system for good. It doesn't have to be negative. If you don't like the way it's being run, you know, you can hire an attorney to advise you how to navigate, and that's probably a much better way to try to resolve things than litigation. We can go to the next slide. So let's say you don't know too many people, not too many people are interested in your issue that you're having with the HOA for whatever reason, getting involved and being part of the community is not working out for you. Now, in litigation, most courts in Colorado are going to require mediation before a trial. So mediation is a great way to start out even before litigation. Anyhow, you don't need a lawsuit to go to mediation, and that may be a low-cost solution. Now, the difference between mediation and arbitration that a lot of people ask is whether one or both are binding. Now, mediation is generally not binding, whereas arbitration is. Arbitration is more like a mini trial in front of an arbitrator who acts as a judge, and as both parties would have likely agreed to prior, whatever the outcome is, they will follow. Whereas mediation is more of a conversation, a negotiation. There's a neutral third party who will listen to the issues and tell you, okay, I think you have a point here. I think this is a solid argument, and they will try to facilitate an agreement that works for everybody. Finally, you have the last resort, which is litigation. Sometimes that becomes necessary and there's no other way to handle it, or maybe you were sued by your HOA and there's already a lawsuit going on. That's the time to hire a lawyer as soon as possible. You don't want to miss any deadlines in your litigation. If you're served with a complaint, you have a certain amount of time to file an answer, and ignoring it, blowing that deadline, these are the worst things you can possibly do. Okay, so next slide, please. So these are the various courts that are available. Small claims court typically is not involved in equitable remedies, such as a declaratory judgment. Typically, small claims court is for money issues that don't exceed $7,500. Now, House Bill 1137 that was passed and put into effect last year actually authorizes parties seeking to enforce their rights and responsibilities under the HOA's governing documents, whether it's for delinquency or otherwise, can actually file in small claims court as long as the issue doesn't exceed $7,500. Typically, however, you would see these matters in a county court or a district court. The jurisdiction for county court is up to $25,000, and that doesn't include attorney's fees or costs as part of the litigation. So if there are damages to your property, if it's less than $25,000, county court is appropriate. If it's more than $25,000, district court does not have a jurisdictional dollar limit like county court does. Next, there's appeals court. Generally, if there is a decision in your small claims county or district court matter, or you have a trial that reaches a verdict, you're entitled to an appeal, and that's when the appeals court gets involved. Finally, there's the federal court system. You'd start out in district court. Typically, you won't see that for an HOA dispute. I suppose it's possible if there's a federal question involved, First Amendment, freedom of speech, that kind of thing. I think that's a very small percentage of cases that we handle in regard to HOAs. And we can move on to the next slide. All right, so 10 pieces of good evidence. Now, I just want to preface this with this. These pieces of evidence can be very useful whether you're involved in litigation or not. If you can present these things at a mediation or present them to the HOA board or the HOA attorneys prior to getting involved in litigation or mediation, maybe end run the whole process and save yourself a lot of aggravation by just showing the HOA up front, look, this is what you said, this is what was decided. It doesn't make sense to go any further. So with that, I will get into it. So emails, voicemails, text messages, written communication, all of that can be very good to show what was decided in the past, what was discussed, how you got to where you are today. We use a variety of tools to extract text messages or emails off of a phone, off of Gmail, for example, is very common. So we can actually use your account or use your phone and extract these pieces of evidence into admissible format. That's very simple, but it's on the homeowner to maintain these records beforehand. It's really important to back up your emails, back up your text messages. You know, if you have something that an HOA board sent to you via email, you really want to make sure that, you know, you're going to have the password to that email account 12 months down the road. Same thing with text messages, you know, a broken phone, a lost phone, having those backed up on the cloud somewhere beforehand can make a really big difference in your case. Now, contracts, typically you might see an application for an architectural review committee. You want to redo your landscaping or make a change to your property. Again, these are important things. The case can turn on this kind of documentation. Next, we have eyewitnesses. Sorry, we can go to the next slide, please. Eyewitnesses are also incredibly important, whether it's another homeowner who overheard a conversation or was present at a meeting for something that didn't quite make it into the meeting minutes. That's really important. If you're involved in litigation, that can corroborate whatever your story is. And it's great. You can do a deposition. You can get sworn testimony and potentially avoid a trial with motion practice because you have other people or even yourself as the eyewitness who can swear to what they saw or what happened and try to shortcut the process as opposed to, you know, dragging it out any more than it needs to be. Professional estimates, expert opinions, engineers and contractors. You know, a lot of people come to us and there's some kind of damage to the property, the home, and then the question is, well, who's responsible for this? Does the HOA cover this? Does my homeowner's insurance cover this? I think at the point where you're getting professional estimates, there's damage to property, it's not a bad thing to talk to your homeowner's insurance first, perhaps, see if filing a claim with them will avoid you having to hire your own attorney, let them evaluate whose responsibility it is. And if it turns out that they're not willing to cover it, they're not able to cover it, then maybe you seek legal advice. Again, this is risk management is really what it comes down to, not getting too involved. But once you're past that point, of course, expert opinions, professional estimates, these are solid ways to document the damage that you have. It's not a matter of estimation or just trying to figure it out yourself. In a court, at a trial, you're going to need something far more specific, and these are the ways to do that with experts, really. All right, so those are my slides. I think the next slide we're going to go to is question and answer.
All right. Thank you, Boyd. Thank you, Joe. Thank you, Peter. That was very valuable information and we appreciate it. So we are going to move into the audience Q&A portion of the presentation. We're going to take some time to answer some of the questions that the HOA Center received leading up to this HOA forum. So for each slide coming up, I'm going to read aloud the question and our panelist members will answer them. We hope you as the attendee will find this Q&A session to be enlightening and helpful as you navigate some of your own challenges that you're facing in your communities. Once we're done with this Q&A session, we'll leave it up to our guest speakers to see if they're able to answer any additional questions posed in the Q&A section. And with that, let's get to the first question here. The question for you guys is, can you speak to voluntary HOAs and whether we need to abide by the rules or not?
Yeah, Nick, I can I can talk about that. You know, and there's some really great questions. We got a lot of questions, and I can see a lot more pouring in right now. We've tried to answer some of them. Some of the questions, I mean, quite frankly, are very complicated, and I understand why you would have that question, and it may be that you do need to seek and consult an attorney because there's a lot of the answer to these questions, unfortunately, is the the typical attorney line of, well, it depends. You know, there's a lot of different factors that are involved and have to be researched, and every single HOA is unique. Each HOA has its own unique governing documents. Some governing documents cover certain aspects, some are silent. So it can be tricky, but as far as this question, voluntary HOAs, I mean, it's kind of some general information is generally that means that there is no board that runs the HOAs. There's generally no dues, or dues are voluntary to be paid. However, there are covenants that are laws or rules for that HOA, and they do have to be followed. However, the remedy, if there's a member or community member not following those covenants, your only remedy may be a lawsuit against your neighbor. There's no board to enforce those covenants. So, you know, voluntary HOAs operate a little different than regular standard HOAs.
All right, our next question here is, can you speak to how an HOA rule or regulation can contradict or possibly override state law?
I think I could jump in on this one. So there's something called the priority or supremacy of law. Typically, that would be federal laws, state laws, and then county ordinances. And then below that, I would say HOA rules or regulations. Typically, HOA rules cannot contradict or override state law. Where there is room for them to grow is, I suppose, well, the best way to put it is they could be more specific. For example, if the county says that the noise ordinances start at 10 p.m., an HOA could be more restrictive and say, actually, in our HOA, late night is 9 p.m. and therefore, you know, you can't be out making loud noises on your property after 9 p.m. That doesn't contradict or override the county rules. And so that would be okay. Whereas something that contradicted it said, okay, you can make noise until 11 p.m. That would contradict state law and that would not be appropriate.
You know, Peter, I get the question a lot from homeowners saying, hey, I am putting in, you know, new landscaping or some new feature on my property. And I went to the city and I got approval through the city, or I got permits to put in, you know, a shed or a building or something on my home. So I started work on it because the city or the county, I got approval. It was legal. But then my HOA came back and told me, well, you can't do that because it's in violation of the governing documents. And well, how can they do that when the city has already given me approval? And I think that kind of speaks to what you just stated, Peter, that you can have something that is in under and is okay by the city ordinances or county ordinances. However, the HOA may have its own rules or its own declaration, which is more restrictive than the city ordinances. And even within the HOA, there's documents, you know, collectively they're called the HOA governing documents, and even they have an order of priority. And really the top document for an HOA is the declaration. That's something that's recorded, and usually it's been recorded years and years ago, back in the 70s or 80s, and that's a recorded document. And all of the documents, including rules and regulations, bylaws, all the procedures, and all of the you know, that have been enacted, they have to comply with the declaration as a whole. However, there's many areas where the declaration is silent, but just because the declaration doesn't say something specific to your issue doesn't mean that the board does not have the authority to make decisions on that issue. Their decisions simply can't be in contrast to the declaration. So hopefully that makes sense, and kind of, you know, just like the declaration of an HOA cannot be cannot contradict CCIOA or some state law or federal law.
And just to add, you know, Boyd gave an example there where you got approval from the county but not, necessarily from your HOA. That's a real important point. You guys should all look at your HOA declarations and find out, often there's what's called an architectural review committee or a design review committee. And, so for example, the county may say, yeah, we approve a 6-foot retaining wall, and you can go ahead and build that in your backyard, but your HOA rules state, no, we don't allow any retaining walls over 3 feet. Well, your county approval doesn't matter. The HOA trumps that, and the HOA can make you take down that 6-foot retaining wall because you didn't seek permission from the HOA in advance and you didn't comply with the covenant. So, just using Boyd's example, make sure you are reviewing your declarations and find out the process with your HOA, and getting approval from the local government, the county, the state, whatever it is. That's not the end all be all. You need to talk with your HOA, find out what their rules, their regulations are. That's why HOAs have the ability to dictate what color paint you can use on your home and things like that. They have these abilities to regulate the community. So really, just using Boyd's example, I thought it was a good trigger point to point out. If you're doing any kind of significant changes, make sure you're looking at your HOA declarations in addition to whatever the county may require or the city.
Yeah, that's a great point, Joe.
Our next question pertains to going to court. This question reads, is the Colorado Small Claims Court an acceptable venue for owner claims against an HOA association for their non-production of association documents requested and required by CCIOA?
I can jump in on this one. So a short answer is yeah, that's an acceptable venue. The general rule of thumb in small claims court is attorneys are not allowed. There's a few exceptions to that. So for example, if you were to sue your board in small claims court, they do have the ability to respond to that lawsuit with their attorney. But for example, Peter, Boyd, or myself, we're not allowed to go file a complaint in small claims court. Our version of small claims court is county court, which Peter touched on earlier. So yeah, I think small claims court is the right venue for seeking production of these association documents. I just, because, as we've touched on earlier, CCIOA does have a reciprocal attorney fee provision. And so to the extent you can keep attorneys away from this whole dispute, it just limits your potential liability if somehow they're able to successfully defend themselves in that small claims venue.
Okay, our next question here also has to do with records requests. What recourse does an owner have for an HOA non-production of association documents that were required by a small claims court order?
Well, I think generally, if a court issues an order and it's not being complied with, you go back to that court and bring it to that court's attention. And so in this case, if a small claims court ordered that records be produced by your HOA is not producing them, whether it's by a motion or a notice to the court, I think that you need to look to that court to enforce the order. I may take some steps before going back to the court. It's just another option to limit liability potentially and bring this to the HOA's attorney's attention, but I think that's the way to do it.
Yeah, and just to add on to that, I agree 100% with you, Peter. I mean, the reality is if someone's not complying with a court order, they can be held in contempt, and contempt allows the court a lot of discretion in how to enforce their order. I mean, going so far as to issue bench warrants and have people arrested. Now, I'm not saying that's likely to happen, but to Peter's point, you should absolutely go back to the court that issued the order, inform them that the board is not complying with the order, and then that judge will exercise his or her discretion on how to enforce that order in a meaningful way. So Peter's correct. You should absolutely go back to the court that issued the order.
And I think, Joe, one more thing just to kind of tie up the small claims court questions. Small claims court is really designed as Joe talked about to operate without attorneys. It's dispute between non-attorneys where they bring their own dispute. There are some limitations to county court. Generally, the remedy in county court is one side pays the other side money. There's some exceptions to that, but that's what small claims courts do, and the max you can recover in small claims court is $7,500. So if you have a money issue that you're trying to recuperate more than $7,500, small claims court is not a good venue. It's really designed, what I tell people is small claims court is really Judge Judy style, where two people go in, bring their complaint, present their evidence. It's not as formal as county or district court. And then the judge, who's usually magistrate, makes that decision Judge Judy style. And so you have that court order that way.
Okay. We're going to shift a little bit to a question posed, or I guess, concerning renters in an HOA. What documentation do owners need to provide to the HOA about their renters? For example, do they need to provide a copy of the rent agreement or the rent term? And what kind of renters information is required to be disclosed?
So I think Boyd alluded to this earlier. Sorry, Nick, did I cut you off?
Oh, no worries. No, you're good, Peter. Go ahead.
Thank you. Sorry. As Boyd alluded to earlier, every HOA is unique, right? So in this question, the answer is it depends on the governing documents. If the bylaws or the declaration state that owners need to provide specific documents, such as a rental agreement with the HOA, then yes, you would need to provide that. Some HOAs have policies where you cannot rent short-term. You have to have a long-term renter, say at least 6 months or at least 3 months or a year, something like that. And they want to see the rental contract for that reason exactly. So depending on your bylaws, depending on the governing documents overall, an HOA could absolutely require the owner to provide copy of the agreement. And then to the second point, provide good contact for themselves or the renters. I think that those are relatively reasonable requirements, and they're possible, but certainly not guaranteed.
Okay. This next one also has to do with renters here. Tenant has violated HOA governing documents for years by continuing to hold all-night parties, loud music, banging doors, cursing, garbage, etc. Should the board require the tenant to appear before them? Should they hold a trial for a person who is not a homeowner?
Yeah, I think on this one, again, you have to look to the governing documents for guidance. Now, I think a general principle is a tenant generally has a lease and a contract with the homeowner. So ultimately, it's the homeowner's responsibility to assure that their tenants are abiding by the by the covenants. And if they're not, ultimately the HOA is going to have that remedy against the homeowner. Now, that can obviously affect the renter, but usually the homeowner or the HOA and the board is going to take action against the homeowner, not necessarily the tenants or the renters. And as far as holding a trial, HOA boards don't really hold trials. A homeowner has the option of requesting a hearing for certain issues, but it's not necessarily a trial. It's a very different beast, and that is with the actual homeowner, not the renter itself.
And I'll jump in real quick to this point. If you are a landlord and you're in an HOA, I encourage you to include a provision in your lease that says that the tenant shall comply with all the governing documents. And now you also have to provide a copy of those governing documents to the tenant so that they can't claim, well, no one ever told me what those were. But that's a layer of protection for you as the landlord. And that way, if they're having late night parties constantly, they're in violation of the lease. It gives you an opportunity to evict them if you need to, which protects you from actions from the board itself on penalizing you.
So just to build off of but what both of these gentlemen have said, if you're the neighbor, you're next door, you're dealing with the brunt of these late night parties and loud music. And this can be extrapolated to other situations as well involving HOA matters. Document, right? I mean, the county is going to have noise ordinances. There's a certain level of reasonability here. Call the police, make a police report if it's really that bad. 6 months down the road, just having a paper list of all the problems that you've observed, that's great. But if you can really have official records and show a paper trail of what's been going on, it's going to be a lot more persuasive to whoever's, addressing the issue.
All right, our next question here is pertaining to HOA's counsel. Is the HOA attorney accessible to members without board involvement if the HOA board is not following community guidelines and covenants? The HOA attorney stated he represents the community, not the board members. So can one member email the HOA attorney to let him know what's happening in the community?
That is a good question, Nick, and can be kind of confusing. And I think the attorney that stated that is correct. I mean, really, the HOA attorney represents the community and the community as a whole. However, the purpose of the HOA board is to be the agent and to speak for the community as a whole. So an HOA, the attorney that's hired by the HOA and its board communicates through the board itself, meets with the board, receives, requests for legal work to be done through the board, not through the community as a whole. You may have, many community members that have their own interests, their own desires, their own wants, and an HOA attorney certainly can't meet them all, and there may even be conflicts between them. So, the HOA attorney has to really look at the community as a whole and what is in the best interest of that community as a whole. So if you have issues as a regular member and you're not on the board, your remedy is to go through the board, to make that known to the board. And like we talked about in the very beginning, if that's not effective, talk to your neighbors, find out if there's more neighbors that have similar issues, attend the board meetings, gather a large number of neighbors if there's that same issue to attend a board meeting. I think board members generally give much more attention if they have a lot of people who are coming to board meetings with the same issue, and finally get involved and actually serve on a board, become a board member. So hopefully that helps.
All right, we might have time for a couple more questions. Boyd, Joe, Peter, if you guys need to cut off or if you'd like to stop, just let us know.
Can I just say real quick, Nick, there are so many great questions rolling in. There really are. I'm scrolling through some of them. Don't possibly have time to address them all. I think as a whole, many of these questions are great questions that, I think you should seek seek a consultation with an attorney for them. A lot of them do depend. There may be some research that's involved in exploring the governing documents or how CCIOA was involved or case law. So if we don't get to one of your questions, then that's the best way to address it. Every answer may be unique. There's not and it may be unique to each board. One answer that affects a community member in one HOA may not be the same for another HOA because the governing documents differ or vary. So.
Okay, well, we did have a few more slides.
Great.
Let's see, there was one here about disbanded HOAs and whether you might have an opinion on dissolved or terminated HOAs. And what are the complete ramifications to the residents?
Yeah, I'm going to let Peter speak to that, as we had that situation, that happened.
Yep. So I handled a case actually where, perfect example of community involvement, a group of homeowners sought the governing documents, interpreted them a bit, and got support from the community. They had a handful of individuals that were elected to the board, and they hired Robinson and Henry to help them dissolve the HOA. HOA is a nonprofit corporation, so there are specific ways to do it. But generally speaking, the first step is to understand what the assets are that the HOA owns. Is there a community pool or is there not, right? So if there's community property, this is complicated exponentially. But assuming there's not, or even if there were, essentially to dissolve this HOA, what you would do is sell common property, and then distribute the assets equally is how we would generally advise this to be done. So the ramifications at that point, if you eliminate the HOA, you eliminate the covenants, the declarations, all those requirements now fall back to state and federal, state, and county law. So if you have an HOA regulation now that says all front doors to the homes in the HOA must be painted red, if your HOA is dissolved, congratulations, you can now paint your front door green, assuming that doesn't violate any state, federal, county ordinance, laws, statutes. But it's an interesting take. Some homeowners, some communities choose to do this, and if you're elected to the board and you hold the vote and you follow the proper procedure, there are absolutely ways to disband an HOA.
Thank you, Peter. Next question is on enforcement issues. My HOA does not seem to be able to enforce our covenants, particularly around landscaping and fencing. They're also not maintaining the common areas, landscaping as well. It feels as if we get little for our dues. How do we get them to uphold our covenants? Communication is impossible. They've not held a meeting since March, and they refuse to print an agenda which states specific topics of discussion for meetings.
I'll jump in here. This is a frustrating situation. You know, they are required, HOAs are required to have an annual meeting. So a meeting has to take place at least once a year. There is an agenda requirement on that annual meeting. But when you feel like the board is not addressing issues with the community, one option, there's a few options, and I'll touch on the primary option, which is that the community members have a procedural right to call for what's called a special meeting. There's different ways to do that. I mean, the shortest version to say is if you can gather 20% of the community members who will sign a petition requesting a special meeting. At that point, the board is required to have a special meeting. There's, again, some notice requirements. There should be an agenda. Meeting has to take place at least 10 days after the notice, but no more than 50 days after the notice. So, you know, if you're running into that situation and you feel like no one's taking the community members seriously, I mean, just as a rule of thumb, whenever you're fighting your HOA, the more allies you can get, the better. And so engaging your neighbors and gathering a communication and getting 20% of your neighbors to agree to call a special meeting forces the board to host that meeting.
Thanks, Joe. Enforcement questions continued here. As an owner of a Colorado townhouse for the past 25 years, I'm extremely concerned and upset that our covenants are not being observed. For example, parking issues, number of dogs allowed in the townhomes, lack of board meeting minutes, which you just described, Joe, lack of timely communications. What can the homeowners who want the covenants followed as required in the purchasing documents do if the board chooses to ignore them and even go so far as to misstate certain requirements?
Yeah, I think the answer to this is the same as Joe just gave. I mean, that's how you get these enforced is the board is there to enforce the covenants as stated. If the board is not doing so, you know, your best remedy is to remove and replace board members or take those actions which are identified in CCIOA or really in your governing documents to see what is required to place that board, replace that board member. Really, I kind of go back to my initial analogy. It's kind of like a small town government. If there's somebody operating in a town or city government and you don't like what's going on, the remedy is you either vote them out and replace them with a representative who's going to represent the voice of the people. So the board members should look at the community as a whole and what's best for it. And if they're not doing so, then the community as a whole, the members can get together and make that change and replace board members. There's a remedy to do that without having to take legal action, incur legal fees, or file a legal action.
All right, we got 3 more slides here. Next one here is on vague rules. Our HOA's covenants prohibit a nuisance, but do not define the term. The board occasionally issues rules and regulations and has attempted to define nuisances as anything the board doesn't like. Most covenant violation letters refer to alleged violations as a nuisance, which the board now claims includes trash cans, untrimmed bushes and trees, brown grass, and weeds. Violations are then published on the form sheet in the HOA newsletter. Is this too broad an interpretation, and how should owners fight back?
Well, no one's jumping on this one. No, these are tricky. I mean, ultimately, at the end of the day, the board is tasked with discretion on enforcing their rules and regulations. And, you know, I mean, you can look to legal definitions of what a nuisance is, how it's been defined in case law and things. But yeah, ultimately, it's going to be a precedent issue. And so if the board has consistently defined a nuisance as, you know, untrimmed bushes and trees, and they're consistent and, you know, applying that across the board, then you're kind of stuck with that definition until, like Boyd said, I mean, the best way to deal with these overzealous boards is to kind of fight them from the inside out, get someone else on the board and start reinterpreting those rules. But generally speaking, the board is given a lot of discretion, and as long as they're not, you know, the buzzword is specifically targeting certain members of the community, you know, this house has a bunch of weeds and that's not allowed, and that house over there has a bunch of weeds, but we're not going to enforce it over there. That's a problem for the board. But as long as they're enforcing the rules uniformly, they're probably going to be insulated from any kind of legal liability or anything.
Although I would just like to point out the shame sheet in the HOA newsletter, that kind of raised the hair on the back of my neck a little bit in terms of privacy violations and naming specific people, things like that. That gives me pause. But generally, I very much agree with everything Joe said.
Conflicts of interest. Can a board member also be a real estate broker and see clients within the community? Is this a conflict of interest? And can you speak to that?
This is a tricky one. I mean, again, it depends on the circumstances. Can a board member also be a real estate broker? Yes. Can it seek clients within the community? Yes, it can. It becomes a conflict, you know, in a lot of circumstances where they're using their position as a board member in order to, you know, unfairly influence those members of the community. This one, you know, it really, you'd have to sit down and look on a case-by-case basis. What are the actions of that board member? You know, how did they go about doing that? Did they, you know, were they doing all actions with the best interest of the community as a whole? So that gets into some, you know, kind of tough legal analysis that you really have to take on a case-by-case basis. And we take a lot of cases where we are evaluating whether or not a board member has a conflict of interest. And that's just, I mean, that's just the only way to handle it, is to look at those specific set of facts and what that board member's done.
And I'll just add on real quickly. I litigated a case all the way up to the Colorado Court of Appeals on one of the issues is the board member conflicted out of enforcing the covenants against my client. Conflicts of interest are very narrowly defined. Board members are believed to be acting objectively. And so, you know, just if your neighbor is the president of the board and you guys can't even look at each other without giving each other the middle finger, that's not a conflict of interest. He can still act allegedly impartially. So, you know, personal fights with someone doesn't necessarily create a conflict of interest. As Boyd kind of touched on, if they're using their position of power and taking advantage of you by using that position, that creates a conflict. But just fights with someone, you don't get along with someone, you feel like they're unfair, they're impartial, that's not going to give rise to a conflict of interest. So just kind of be prepared, because it's a common question. You know, this president and I have had a lot of interactions and we don't get along, and I don't think it's fair that he's judging my situation. That doesn't create a conflict. So just kind of be prepared for that.
Okay, last slide here, guys. And maybe this is our favorite one. This one is has to do with bad board members. How should we stand up to a bully president? And what can I as a homeowner do if my board of directors continually makes community decisions by way of work sessions instead of in an open and transparent board meeting.
Yeah, I mean, bully president, that's a, it really depends on what the president is doing. I'm not sure what that means, but as we've kind of talked about several times, the best way is to talk to your neighbors and get involved, see if there's other neighbors who are having similar issues, and then look at your governing documents, see what remedies you have as far as board meetings, attending board meetings. What does it take to remove and replace board members or a board president, and go through those steps, go through that due process of what it takes to make that change. It's not always, something that's a legal issue. It's often a more of a community due process issue, and going through the process of first of all, knowing what your governing documents and CCIOA and the other laws that are applicable, what do they require? And is it really, what is the remedy that you have, outside? Now, there may be certain situations where there is a legal remedy, where there is some sort of demand that you can make, where there is, a lawsuit, and that's something that we would have to go through and analyze. These questions that we've had and the ones in the Q&A are exactly the type of questions and cases that we work on every day. And these, we are happy at Robinson and Henry. We have a great website at robinsonandhenry.com to go on to make an appointment for a consultation and to help to kind of address these issues or talk through them. So,
and I would just, one last thing to that point, Boyd, if it gets to the point where going about it without involving an attorney, without getting involved in litigation, has failed and it's not possible, you can speak to an attorney there. If you really believe that your board of directors, your president are making decisions in bad faith that are not in the best interest of the HOA, there are types of litigation that you can go into where you get 5% of the HOA community together, and you could bring a lawsuit for to challenge the decisions that your board has made.
Okay, well, this concludes our HOA forum on attorney perspectives. The Division of Real Estate, we just really wanted to thank Boyd, Joe, and Peter for joining us today. I think our attendees got a lot of valuable information from this session, and we encourage you as an attendee, if you had any follow-up questions, to reach out to Robinson and Henry with any extra questions you may have. And I just wanted to see if Peter, Boyd, did you guys have any final concluding remarks before we ended the session today?
No, just we appreciate all of the questions. I wish we could sit down and go through each and every one. There's a lot of them. Hopefully we've kind of given some general information and principles to help address some of those. We're happy to speak with anyone regarding those questions. So.
Yeah, I'll just second what Boyd said. I mean, an attorney's favorite answer is it depends. That's what we love to say. And a lot of these questions, it depends. And so, I do encourage you to reach out and set up a consultation, hopefully with Robinson and Henry, but whoever you talk with, and try to get some of these answers. Don't necessarily engage a lawyer and pay them necessarily. First, try to have a conversation with them, because a lot of these questions, well written, can be resolved without lawyers necessarily. So something to think about.
Just echo what Joe and Boyd said. Yeah, I think that there's a lot of specific questions that we've gotten, and I think it's worth looking into. It's worth having a consultation and digging in, see if you can resolve your issue. Thank you, Nick, for putting this together. Shout out to Mandy for this award-winning presentation she put together, and thank you, Joe and Boyd.
All right, thanks, guys. I hope everybody has a great weekend, and we'll see you later. Thank you very much. Have a nice day.
Thank you.
Thank you all.